Heading for hearing under order 41/11 of CPC, item
He's
29.
correcting in order. That is why I got late.
Item 29, second appeal 30 of 2020.
I'm praying for a short pause for one or two cases.
I don't need you. Only substantial question of law is to be followed. Yes, please.
This is a concurrent finding. There was no dispute regarding the
So it
land,
was hopelessly barred by limitation.
but that is regarding the partition, but not the encroachment which arose in 2008. Because the cause of action for this suit,
You are seeking recovery
because of the
of
two
the
decimals,
encroached.
which
That's
are
right.
encroached.
That's right.
Ah.
But that had that
has been-
itself has been held to be barred by limitation.
That has been recently done.
This is not there. Rather, there is a clear finding that the boundary wall was constructed much
Long
prior to
road.
that. And then there is also a finding that the construction
They have
was
made
within the
construction.
boundary wall.
Ah.
Everything
And
is
this plaintiff
there.
is not saying the defendant took advantage and yet construction based.
So that is the thing. There is nothing in this case. Okay. Essay number 30 of 2020. Heard the learned counsel pleading on behalf of the appellant. This appeal has been filed against the judgment and decree dated 9/8/2019, within bracket decree signed on 23/8/2019, passed in civil appeal number 31 of 2012 by the Court of Learned District and Additional Judge Romanji Saraikela, whereby the appeal has been dismissed and the judgment and decree dated 4/8/2012 within bracket decree signed on 15/8/2012 passed in statute number 9 of 2010 has been upheld. The suit was dismissed and the plaintiffs are the appellants before this court. The learned counsel for the appellant has submitted that though there are concurrent findings recorded by both the courts, but the courts have failed to consider that the construction, that the encroachment was of recent origin, and therefore the suit was wrongly held to be barred by limitation. That's it. After hearing the learned counsel for the appellant and upon going through the impugned judgment, this court finds that the suit was filed seeking declaration of right title interest and for recovery of possession of the suit land. The specific case of the plaintiff was that they had purchased the suit property by virtue of a registered sale deed dated 21/3/1958. The suit property was purchased by Praful Kumar Pramanik, father of plaintiff number 1, 3 and 4, and pro forma defendants, and husband of plaintiff number 2. Who also died during the pendency of the suit. It was their case that the suit property was recorded in the name of Praful Kumar Pramanik in the last survey settlement operation published in the year 1961 under plot number 171, khata number 21. It was their further case that the father of the principal defendant, late Ramanand Goswami, had purchased the adjoining south of the land which was purchased by Praful Kumar Pramanik, and it was recorded as plot number 172 of the last survey settlement operation. And Ramanand Goswami had constructed a residential house over the same land. The dispute cropped up. It was their further case that during the lifetime of Praful Kumar Pramanik and Ramanand Goswami, some dispute cropped up between them, and the land was measured by government Amin, and the dispute was amicably settled. It was their further case that after death of Praful Kumar Pramanik, the plaintiff has been in exclusive possession of the land belonging to Praful Kumar Pramanik, plot number 171. Since the plaintiff number 1 is a government employee and taking advantage of absence of plaintiff, the defendant number 1 started encroachment over the suit land by making certain construction, and a proceeding was also initiated by the local police under section 107 CRPC, but ultimately the proceeding was dropped. According to the plaintiff, the principal defendant had encroached portion of plot number 171 of khata number 21 measuring to dispute. And ultimately the suit was filed. The sole defendant, the principal defendant number 1 filed his written statement alleging that the suit was barred by limitation and there was no cause of action. However, in his written statement, he admitted that Praful Kumar Pramanik was the owner of RS plot number 171 of khata number 21, and that his father was the owner of RS plot number 172, which was adjacent south to the land of the plaintiff. It was his further case that the father of the plaintiff and the father of the defendant number 1 were peacefully living together as neighbors, and there was no dispute between them. It was further stated that the topographical shape of the land and the plot number 171 and plot number 172 were otherwise crackjacked, and hence both of them extends at 2 corners of land vice versa, and Amin was engaged to measure the land and adjusted the area to make the boundary of the land between the plots in a straight line by removing the old shape. Thereafter, a boundary wall was erected between their respective land, and no dispute ever arose between them after the amicable settlement. It was denied that the defendant at any occasion had encroached upon any portion of the land of plaintiff in this regard, and it was submitted that there was no scope or reason for making any encroachment as alleged by the plaintiff. It was stated that there is no dispute that the defendant has constructed the house in his area of plot number 172. Both the parties led oral and documentary evidences in support of their case. After framing of issues, which is at para number 10 of the trial court judgment, quoted as under. The trial court took up issue number 6 and 7 and considered the oral and documentary evidences of the parties and recorded that the predecessor in interest of both the parties had amicably settled their interest and had erected a wall between the two plots and settled all the disputes between them. It was also recorded that the evidence of the plaintiff himself themselves deposed. Witnesses of the plaintiffs deposed that the construction was sought to be made by the defendant within their area of the boundary wall. And it has also come on record that the boundary wall was constructed long back. The learned court ultimately held that the plaintiff and his witnesses admit that the parties are within the limit of the demarcation line as made by their predecessor in interest, and ultimately held that there was no encroachment by the defendant number one over the area of the plaintiff. By considering the point of limitation, the learned court held that by deciding issue number 3, the learned court held that the suit was barred by limitation and recorded the finding as under issue number 3 का छोटा सा finding at running page 27, internal page 6 of the trial court statement. The learned first appellate court also considered the materials on record and framed the following points for determination. Page number 12 of appellate court's judgment, 10 points for determination. And all the points for determination were decided against the plaintiff and in favor of the defendants, and ultimately the appeal was dismissed. The learned first appellate court also recorded that the plaintiffs and their witnesses have also admitted in their respective evidences that the parties to the suit are within their limit of demarcation of line as made by their predecessor in interest, and held that there was no encroachment made by defendant number 1. The point of limitation was also decided under point of determination number 2 by paragraph 13 of the appellate court's judgment, and it was held that the suit was hopelessly barred by limitation. This court finds that there are concurrent findings recorded by both the courts after considering all the materials on record. Both the courts have held that the defendant number 1 was acting within the boundary wall erected between the plots of the respective parties by their predecessor in interest. Way back in the year 1960, and the parties were in peaceful possession of the same. The plea of encroachment was rejected. The counsel for this court finds that there is no perversity with respect to the appreciation of materials on record as such has been pointed out by the learned counsel for the appellant. This court finds that both the courts have given concurrent findings while dismissing the suit, and accordingly no substantial question of law arises from that suit. This appeal is accordingly dismissed.
Item 30, second appeal 70 of 2021.
Who is for the appellant?
Let the name of the for the applicant, but name of Mr. Balla ki was denied. Your colleague was there.
Where is he? There is no merit in this case. Still absent.
He was just here.
He is coming?
I don't know, but he was here.
He was here?
Yeah. Well, this case I could not understand what I have to argue.
There is nothing.
I must एक चीज केवल हम ये नहीं समझ पा रहे हैं कि पार्ट जजमेंट को हम लोग चैलेंज किए, एक सेट के साथ तो कॉम्प्रोमाइज हो, दूसरा सेट केस अगेंस्ट में किए, उसके अगेंस्ट में काउज ऑफ एक्शन भी क्लेंट में कोर्ट का लंदन फर्स्ट अपील कोर्ट का फाइंडिंग हम, और उन लोग अपीलेट स्टेज में एक खतियान को प्रोड्यूस किए कि भाई हम लोग खतियानी रहे थे, उस पर उनका कर दिया। केवल हम एक एग्जामिन कर लेते हैं कि उनके अगेंस्ट में
हम पढ़ रहे हैं, कुछ नहीं, अभी बोल ही रहे थे कि कुछ नहीं ऐसे
हम तो
हैं, कुछ है ही नहीं आपके केस में।
तो एक चीज केवल यही है, हम इसलिए
एक आर्गुमेंट तो खड़े हुए थे, एक आर्गुमेंट तो रिकॉर्ड कराइएगा करें।
तो वही हम तो स्पष्ट बता दिए।
नहीं, आप तो कह रहे हैं इसलिए आपको सुनते भी हम एक डेढ़ घंटा भी सुनते हैं।
कल तो 2 घंटा माय लॉर्ड,
कल 2 घंटा हम सुनते। ऐसा सुनने में कोई कमी नहीं है,
कभी
देखने से
बोले
लगता
बिना
है।
फाइल ओपन किए हम कहे कि एक से के साथ तो कंप्रोमाइज कर लिए, अब बचा केवल पार्ट में उनके अगेंस्ट में फाइंडिंग है कि प्लेट
खतियानी रैयत का ही वो डिसेंडेंट।
हाँ खतियानी रहे, लेकिन खाली एक चीज है कि केवल खतियान के बेसिस पे उसका
नहीं, आपने बोला था कि सत्यवती का है प्रॉपर्टी, लेकिन आपने उसका ना खतियान प्रोड्यूस किया, ना कोई डॉक्यूमेंट, कुछ भी नहीं प्रोड्यूस किया।
रिटर्न भी बोलते हैं,
कुछ नहीं प्रोड्यूस किया आपने, कोई डॉक्यूमेंट नहीं।
हालांकि तो परचेजर है रजिस्टर्ड डीड से,
तो क्या हुआ? लेकिन आप जब बोल रहे हैं कि खतियानी रैयत है या मान लीजिए खतियान से ड्रॉ कर रहे हैं कोई चीज, तो डॉक्यूमेंट तो प्रोड्यूस करना पड़ेगा।
प्रोड्यूस करना पड़ेगा केवल एक एग्जाम इस पर्पस से कि केवल खतियान के बेसिस पर, उसके बाद अगर मान लीजिए कभी दखल में रहा ही नहीं,
एडवर्स पोजीशन का केस नहीं बनाया,
उसके अगेंस्ट में बोलते हैं कि कोई काउज ऑफ एक्शन ही प्लेट में नहीं बोल,
कौन
मतलब हम अपने अगेंस्ट में बोल रहे हैं।
हाँ, समझ रहे, कोई कॉज ऑफ एक्शन नहीं है।
नहीं, तो एक चीज इसलिए हम केवल देखना चाह रहे हैं कि अगर काउज ऑफ एक्शन उसके अगेंस्ट में बनेगा, तो हम अगर बनेगा तो हम ये
हमको क्या ही बोलना है, आप पोजीशन में हैं।
हाँ हम तो पोजीशन में हैं,
तो जब आपको कोई हटाने आएगा तो आप अपना एडवर्स पोजीशन क्लेम करिएगा,
तो
उसमें क्या
चलिए
दिक्कत?
ठीक है, इसीलिए तो
हम कुछ दिखाएंगे तो
नहीं, हम ये नहीं
लॉ विल परमिट यू,
नहीं।
आई एम नोबडी टू परमिट यू इन सेकंड अपील।
तो है
कोई परमिशन हमारा
परमिशन अगर लॉ देता है तो
लॉ
देता है,
देता है तो देता है, नहीं देता है। एक भी ऑब्जर्वेशन इधर उधर बहुत दिक्कत हो जाता है।
तो हम वही सोच रहे थे कि क्या हम विड्रॉ कर ले इस लिबर्टी से, लेकिन चूंकि हम ये एकदम वेरी फेयर इसलिए बोले कि चूंकि गांव का क्लाइंट लोग है तो हम
नहीं ऐसे
करते भी
नहीं,
नहीं,
ये इंस्ट्रक्शन नहीं है विड्रॉ करने की।
हाँ हमने तो बुलवा करके एक बार सोचे कि
नहीं बुलवाना क्या क्या है,
एक सेकंड अपील का अगर फाइंडिंग आ जाएगा उसके अगेंस्ट में,
फाइंडिंग क्या, हम तो बोलेंगे कोई सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं है, क्या फाइंडिंग है? अभी तो क्या ही मर्ज होगा इसमें, मर्जर तो नहीं होगा ना, कुछ नहीं होगा। There is no substantial question of law. बस इतना ही.
वही करके खत्म करें।
देखिए second appeal number 70 of 2021. Heard the learned counsel appealing on behalf of the appellant. This appeal has been filed against the judgment and decree dated 7/7/2021 with the bracket decree signed on 19/7/21 bracket close passed by the District Judge Roman 6 Chatra, whereby civil appeal number 12 of 2018 has been allowed in part and the judgment and decree dated 26/3/2018 within bracket decree signed on 3/4/2018 bracket close passed by learned civil judge within bracket senior division bracket close 1 Chatra in original suit number 13 of 2012 has been set aside. The learned counsel for the appellant has submitted that there was a compromise with the before the first appellate court
With the appellate number 1
with
to
the
6.
appellant number 1 to 6.
Yes.
Namely, Shivati Sabita Devi, Vijay Saw, Vinod Saw, Ajay Saw, Munna Saw, and Anil Saw. And therefore, the appeal was disposed of in terms of the compromise in connection with respect to the land in Khata number 6, Kesra number 180, area 1.04 acres. The compromise petition dated 6/7/2021 was allowed, and therefore the appeal was only restricted to the other property, that is Khata number 40, Kesra number 185. Correct? The learned counsel for the appellant, by assailing the impugned judgment, has submitted that the
Para 26.
first appellate court has allowed the appeal primarily on the basis of additional evidence.
Only on the basis of Khatiyar Exhibit E and not a single document.
Only on the basis of cadastral Khatiyan Exhibit E, which was run in the name of Sohrai Mali and sister of defendant number 8 and 9, and no further document was produced on behalf of the defendant. The learned counsel has submitted that the Khatiyan
41,
was
yes.
produced by way of additional evidence before the learned first appellate court, है ना?
Yes.
Which is apparent from paragraph number
Paragraph 22.
which is apparent from paragraph number 22 of the first appellate court's judgment. The learned counsel submits that a substantial question of law be formulated and be submitted.
The only ground I have raised, my lord, that the learned first appellate court has not examined anything which is evident from paragraph 26. Only in one paragraph saying the case of the defendant, and nothing has been examined in order to appreciate the case of the plaintiff and the defendant. Finally, see paragraph 26.
पहला 11 से तो पूरा ही एग्जाम
हाँ देखा लिखा जाए वो केवल और केवल उससे के संबंध में है.
The learned counsel for the appellant has also submitted that the learned first appellate court has not considered the case in totality, and primarily the case has been decided on the basis of exhibit. After hearing the learned counsel for the appellant, this court finds that the plaintiffs had filed the suit for declaration of right title and interest over the suit land described in Schedule 1 and 2 of the plate, and also sought confirmation of possession, and if found dispossessed, for restoration of possession after evicting the defendants. The case of the plaintiff was that the suit land was owned by one Satyavati alias Savitri Devi, who executed power of attorney in favor of one Dr. Naresh Chandra, who in turn executed sale deed number 7137 in favor of Kedar Yadav for land of Khata number 6, plot number 180, area 18 Disney, and sale deed number 7140 in favor of one Lalita Devi for land under Khata number 6, plot number 180, area 52 Disney. And thereafter, Kedar Yadav and Lalita Devi executed sale deed number 3491 dated 7/5/2010 in favor of plaintiff number 1 for land under Khata number 6, plot number 180, area 68 decimal. The same plaintiff number 1 also purchased 72 decimal of land of Khata number 6, plot number 180, area 50 decimal, and 10 decimal of land of Khata number 42, plot number 183, area 2 decimal of plot number 183, and 10 decimal of plot number 182 from Dr. Nagesh Chandra Singh by registered sale deed number 7141 dated 23/12/2008 on the basis of genuine power of attorney executed in favor of Nagesh Chandra Singh by Savita Devi. It was their further case that plaintiff number 2, Satyavati Devi, purchased 88 decimal of land of Khata number 40, plot number 185 by sale deed number 143 from Naresh Chandra Singh on the basis of genuine power of attorney. And it was also pleaded that all the purchasers came in possession of the suit property and the land was mutated in their name. It was their further case that one Ashok Kumar, who had no right title and interest over the suit property, and one Hari Sao executed an illegal sale deed in favor of defendant number 2, Srimati Savita Devi, with respect to an area of 1.25 acres appertaining to Khata number 6, plot number 180, area 1.04 decimal, and Khata number 51, plot number 107, area 21 decimal, on the basis of illegal power of attorney, alleged to be executed by Ashok Kumar in favor of Hari Sao with respect to the suit land. And thereafter, the defendants have been illegally claiming right title interest in possession with respect to the suit property. The cause of action arose on 22/3/2012 when the defendant took attempt to dispossess the plaintiff, and ultimately the suit was filed. A joint written statement was filed by defendant number 1 to 7, denying the case of the plaintiffs, and also denying that there was no cause of action, and that the suit was barred by limitation, and also claimed adverse possession. The suit was hit by its specific fact. It was the case of the defendants that Ashok Kumar got a registered power of attorney dated 3/2/1989 from Srimati Satyavati Devi, alias Savitri Devi, with respect to Khata number 6, plot number 180, area 2.04 acres, and Khata number 51, plot number 107, area 1.21 acres. And thereafter, Ashok Kumar Singh executed power of attorney dated 5/2/2009 in favor of Hari Sao before notary public, getting permission from Satyavati Devi with respect to the land in question. And on the basis of this power of attorney, Hari Sao executed sale deed number 1321 in favor of Savita Devi for total 1.25 acres under Khata number 6, plot number 180 and Khata number 51, plot number 107. After purchase, defendant number 2 Savita Devi applied for mutation and her name was mutated and she was paying rent to the government. The plaintiff had no right, title and interest in possession with respect to the suit, with respect to the property purchased by defendant number 2. Savitri Devi. There was another joint written statement of defendant number 14 and 15, and it was pleaded that the plaintiffs were not in possession of the suit property. It was further pleaded that the land of Khata number 6, plot number 180, area 2.04 acres was recorded as Gair Madiwa Khas land of ex-landlord of village Lone Singh Kala named Babu Viren Visheshwar Singh. The defendant number 14, Kameshwar Mali, was the second rayat of the land measuring area 25 decimal out of 2.04 acres of land of Khata number 6, plot number 180, on oral permission of ex-landlord Babu Visheshwar Singh. And in Samvat 2001, issued Hukumnama in favor of Kameshwar Mali for the land measuring 25 decimal out of 2.04 acres of land of Khata number 6, plot number 180, and for land measuring 50 decimal out of 64 decimal of land of Khata number 19, plot number 172, and accordingly issued zamindari rent receipts in his favor. The defendant number 14 and 15 were own brothers who were enjoined cultivating possession of the second land, and defendant number 14 was recognized as rayat and demand register was opened in his name. They were paying rent to the government, and they had also amicably partitioned this land. It was also pleaded that Khata number 40, plot number 185 of village Losi was recorded in the name of one Sorai Mali, who was a grandfather of these defendants, and it is continuing in possession of these defendants, and that the plaintiffs had got no cause of action. So far as defendant number 8 to 13 and 16 and 19 are concerned, 16 to 19 are concerned, they did not appear, and the suit was ex parte against them. The following issues were framed by the learned trial court. Both the parties made oral and documentary evidence. The learned trial court discussed the materials on record and while considering issue number 6 and 7 and considered issue number 6 and 7 together. And held that and observed that in common law, two separate standard of proof are recognized: proof beyond reasonable doubt and proof based on the balance of probabilities. And while considering the civil suit, the balance of probabilities is to be considered. The court held that the plaintiffs had successfully established his title and possession over the plaintiffs had successfully established their title and possession over the suit land, and they were entitled for declaration of title. And ultimately, the issues were decided, both the issues were decided in favor of the plaintiffs. Internal page 19 the trial court judgment का मार्क कर इसको थोड़ा The issue number 1 and 2 were decided in favor of the plaintiffs and issue number 3, 4 and 5 were recorded as not pressed. And ultimately the suit was decreed on contest against defendant number 1 to 7 and 14 to 15 and ex parte against the remaining defendants. The operative portion of the judgment of the learned trial court is as under ordered. So far as the learned first appellate court is concerned,
प्लेंटिफ का टाइटल डिक्लेयर नहीं हुआ था
sorry,
लास्ट पैराग्राफ लास्ट पेज में उसमें इट इज मेड क्लियर दैट द प्लेंटिफ्स हैव नो राइट टाइटल इन इंटरेस्ट ऑन खाता नंबर 51 प्लॉट नंबर इतना डिक्लेयर 21
the learned trial court held that the plaintiffs had no right, title and interest over land of khata number 51, plot number 107, area 21 decimal. Right?
यस
यही प्रॉपर्टी
हाँ,
इन्वॉल्व है इसमें.
नहीं मतलब इसके बाद और दिक्कत इसमें बोल दिया कि आपका कुछ नहीं है इससे आगे इसमें अपील नहीं किया प्लेंटिफ
ठीक है. So far as the learned first appellate court is concerned, point for determination कहाँ है? The sole point for determination was framed in paragraph 14, that is, whether the plaintiffs have title and possession over khata number 40, case number 185.
Para 25 is relevant for 7.
Sorry?
Para 25.
The fact remains that with respect to the property in khata number 6, case number 180, area 1.04 acres, there was a compromise and there was no occasion for the learned first appellate court to go into the and the learned first appellate court had disposed of the matter in terms of compromise with respect to the same property. At the first appellate stage, additional evidence was led and
पैरा 19
additional evidence was led and defendant number 14 and 15 who were appellant number 7 and 8 produced khatiyan of land of khata number 40 plot number 185 which was marked exhibit E and in paragraph 22 of the judgment it has been recorded that it was running in the name of Sonai Mali, son of Gokul Mali.
Appellate court has also taken into consideration that not a single line about 7 and 8 they have written in the plan. That is in page 25. Page para 25.
The learned
In the middle manner.
yes,
Plaintiff in his plaint has not attached a single line about the respondent number 7 and 8.
the learned first appellate court also took into consideration that the plaintiff in their plaint had not stated a single line about the respondent number 7 and 8 who were defendant number 14 and 15 in the trial court. So, in the pleading, no case of the plaintiff with regard to these defendant number 14 and 15 was made out. The finding of the learned first appellate court has been recorded in the learned court also took into consideration the fact that the plaintiff witness in his cross-examination had stated that in the survey Khatyan, he saw that the Khatyan was recorded in the name of Satyavati Devi. Although at the first appellate stage the Khatyan was exhibited and as additional evidence with respect to Khata number 40, plot number 185, exhibit E, which stood recorded in the name of Sonai Mani, son of Gokul Mani. Ultimately, the learned first appellate court recorded the finding in paragraph number 25 and 26 as under. This court finds that the learned first appellate court has rightly considered the materials on record, including the pleadings of the respective parties and also the additional evidence which was brought on record at the first appellate stage, that is exhibit E, whereby the property was recorded in cadastral Khatyan, exhibit E, in the name of the in the name of Sorai Mali, son of Gokul Mali, who was admittedly the ancestor of defendant number 14 and 15. 14, 15 ke the ancestor, right? Considering the totality of facts and circumstances of this case, this court is of the considered view that no substantial question of law is involved in this case, which is accordingly dismissed.
Great.
You file a caveat in the my name may be.
Caveat का क्या करें?
सर जी के सर का नाम है
Otherwise I would not have said.
ठीक है, आपका appearance record है।
हाँ, मेरा caveat है इसमें. That's why I'm asking.
ऊपर ही लिखा है।
Otherwise, order 41
The respondent has entered appearance through caveat, and the learned counsel for the respondent is present in the court. However, for the court, बस इतना ही काम है।
आगे सर का नाम
Please पूरा बनना चाहिए। चलिए।
DTO.
But filing for Kalapnama, we also have some.
Oh yes, certainly.
The plans.
Certainly.
Otherwise, they will say you are not appeared.
हाँ, ठीक है।
Item
थोड़ा तो
31.
आप हमको assist कर ही दिए, ऐसा तो नहीं।
I did my duty.
Item 31, second appeal 80 of 2021.
इसका ना सारा जजमेंट्स जो है सप्लीमेंट्री में, इसका बाकी रिकॉर्ड जजमेंट होती नहीं है, इसका और भी रिकॉर्ड होता है। मुझे फ्लैग किया हुआ है, बस मेरे हाँ बोलो।
The instant second appeal is against the order of reversal. The plaintiff filed title suit number 9 of 2003
You are the plaintiff?
and the defendant
You are the suit was
dismissed.
suit dismissed,
Against which suit dismissed,
appeal allowed,
appeal allowed. Against which the
defendant is the
appellant. Yeah.
That's right. Tell me what is your question of law?
That's it.
What is your question of law?
Question of law. First question was whether the first appellate court can discard the principle of law that the entries in RS Khata, latest survey settlement shall prevail when the same has been duly framed and
You
published
are
in the
claiming on the basis of a registered sale deed,
Yes.
right?
And
That registered sale deed does not contain the plot number. Matter ends.
in the registered sale deed, the plot number instead of 2198 is 2192.
2192 was mentioned. So you have to, the deed has not been rectified.
The deed, but the area and the boundary is there, and boundary shall prevail. When there is an erroneous entry in the sale deed,
No, we do not.
With respect
You
to-
have to get it rectified. How can this be done?
but the area of land, the nomenclature of the land,
No, whatever.
everything is there in favor of the as per the deed.
It was not your case that it has been wrongly mentioned in the deed. That was not your case. Had it been your case that it has been wrongly mentioned in the deed, the matter was different. But
Yes.
that was not your case. Now we are trying to make out a new case that it has been wrongly mentioned in the deed.
But
And
as per,
in
as
fact,
per
the registry receipt, the document from the registry office was also called for.
Yes.
Wherein it was clearly mentioned as plot number 2198, 2192, sorry.
2192,
Yes.
but the khata number, the 2192 does not comes within the khata number 89.
We do not know.
It is not
That
there.
is not your
And
case. If you have not made out a case, I can understand that there can be some error. But you have to make out a case to that effect, that in the registered document there is an error. And you know how the registered documents are rectified. There is a provision for rectification of the error in the registry document. And as you said that identity is not in dispute, there is an error in the registered document. That is not your case.
That is not there.
Then
That is not there. But in fact, as per the physical possession, the RS record of rights has been prepared, and out of 9 decimals, I have already sold 1 decimal to Kabarstan, and that has been deducted during the survey settlement. Total 8 decimals of land has been recorded in mine, and it is evident from the judgment of the trial court also. Internal page of the trial court judgment, Lordship, page 4.
page 4 is
Pa-
is your
page-
case.
page- yes, paragraph 12. It starts from. Will be permitted to.
Just a moment. फर्स्ट हाफ में जो लोग थे वो लोग हैं कि देखने के लिए ऑर्डर बुलाइए उनको मिस्टर सुदर्शन श्रीवास्तव को
Paragraph 12. The defendant have denied a genealogical table as well as genealogy given in plain. It is further case of defendant that it is false to say that the land under Khata number 89, area 1.02 decimal, having several plots.
पैरेट 12 किसका पैरेट 12
ये trial court first. Trial court. Running internal page 3 of the judgment. इसमें एकदम clarify करके specific करके.
पढ़िए
Paragraph 2. The defendant have denied genealogical table as well as genealogy given in plain. It is further case of defendant that it is false to say that the land under Khata number 89, area 1.02 decimal, having several plots, including plot number 2198, area 0.09 acres, in joint family property, rather all recorded rayas during their lifetime, partitioned the property recorded in their name orally and according to village custom, Bakuda Batwara, and the aforesaid property allotted to the share of Sheikh Jamlu, recorded raya. After partition, all recorded rayas were separate in mess and cultivation, and all of them had in exclusive possession over their respective share, and accordingly, all recorded rayas, as per their need, transferred their respective share to different persons through registered deed of sale and admitted the partition mentioned therein Bakuda Batwara. Likewise, Sheikh Janglu transferred his share total and area 1.02 acres, including plot number 2198, area 0.09 acres to registered sale deed of sale, deed of sale by deed number 2693 dated 38/1966. That is in my favor. In favor of the defendant, taking full consideration, and since then defendant acquired right, title, interest and possession over the same within the knowledge of all concerned and got her name mutated and has been paying rent regularly, obtaining rent receipt in her own name. It is further case of defendant that if property in suit is joint property, then all legal heirs and successors of all recorded heirs have to be made party in this suit, as their interest also involved in this suit. It is further case of the defendant that the defendant is in possession over an area 0.09 acres of plot number 2198 since the date of purchase and has constructed his house and khalihan covered by boundary wall on it within the knowledge of all concerned, and in the year 1997 plaintiffs Bhuvan Ansari along with his sons destroyed the boundary wall aforesaid, against which the defendant had filed a complaint, case being complaint case number 90 of 1997, and after trial all accused persons have been found guilty by court and accordingly sentence passed against them. It is further case of the defendant that the defendant has gifted 0.01 acres of land out of 0.09 acres of plot number 2198 for the use of common people, and the land so denoted is used for Idgah. At that time, no one has raised any objection. Even in a recent survey operation Khatiam prepared and published in the name of defendant, being Khata number 657, plot number 2453, area 0.08, after deducting 1 decimal in favor of Idgah acre within the knowledge of all concerned, but neither plaintiff nor legal heirs of successor of other recorded heirs has taken any action to correct the entry made in the recent survey Khatiam, which confirm the possession, right, title and interest of the defendant over this property in suit. It is further case of defendant that the alleged cause of action is false, fabricated and concocted for the purpose of this suit. It is further case of the defendant that cause of action of this suit arose first time in the year 1996 when proceeding under section 144 CRPC initiated between the parties, and lastly on 11th March 1994 when present survey Khatiam published in the name of defendant, but no action has been taken by the plaintiff, and as such present suit is barred by law of limitation. This is the case of the defendant. And the learned trial court para 20 onwards, you see, running page 7, internal page 7.
उनके पास टाइम नहीं है देखने के लिए, I can't do it. नहीं देखिए, एक बार अपलोड हो जाने के बाद आपके पास कोई ऑप्शन नहीं है, आपको दिखाने की कोई जरूरत भी नहीं।
आएंगे।
Paragraph 19. Paragraph 19. I further find that Exhibit A, A by 1, A by 2, A by 3, A by 4, A by 5, which are registered sale deeds, shown that Sheikh Bhutan, who is the father of one of the plaintiffs, Sheikh Majid, who is also father of another plaintiff, and Sheikh Bhuvan, son of late Masih, and grandfather of one of the plaintiffs, have sold lands from RS Khata number 89 from different plot from time to time, and it has been this 2198 is also within Khata number 80 from different plot from time to time, and it has been mentioned in the said deed that vendor obtained the land by way of partition, Bazaria Bakuda Batwara. Further, find that in the name of Sheikh Jaglu had also sold the said suit land to Bibi Mako, the original defendant. I find that although defendant's witness had admitted before the court that they had not seen the partition paper and do not know which co-sharer got which plot, but in spite of this fact, the different registered sale deed executed by the ancestors of the plaintiffs prove the fact that partition had already been taken place when Sheikh Jaglu had sold the suit land to Bibi Marco. Para 20. Now I find that PW1 in cross-examination admitted that Bibi Marco Bibi had instituted a criminal case for allegation of breaking of a boundary wall on him and his son, in which they were fined. He further admitted that in appeal they were acquitted, and he has filed the paper regarding the appeal, but I find that no paper of appeal has been filed by the plaintiff to show that they were acquitted in the appeal against the conviction. PW2 contradicting admitted that the Bibi Marco had not instituted a case upon Bhuvan Ayub, Sayub and Manan regarding the boundary wall. He only admitted that the case was instituted regarding dispute of fetching of water from well. However, Exhibit D is the certified copy of complaint case number 90 of 97, which shows that Marco Bibi had instituted against Bhuvan Ansari, Ayub Ansari, Sayub Ansari and Manan Ansari. It shows that case was instituted by Mako Devi on allegation that Bhuvan Ansari, Ayub Ansari, Sayub Ansari and Manan Ansari have damaged the boundary wall of the land of Mako Devi. I find that they were found guilty. He further admitted that over the land of Khata number 89, plot number 2198, there is Khalian, and over some portion of the land there is house which is constructed by Marco Bibi, but she do not reside in it. I further find PW3 in his cross-examination admitted that he do not know what is written in the examination sheet supported by an affidavit, and he also do not know what is present case for. I further find that PW5 has proved 3 rent receipts, which are marked as Exhibit 1, 1 by 1, 1 by 2, respectively. But in cross-examination, he admitted that rent receipts are not issued in front of him. I further find that PW5 has proved the original copy of registered sale deed, volume entry bearing 2693, dated 3/11/1966, which is marked Exhibit 5 by 1. But in cross-examination, he admitted that volume entry is made according to original sale deed. But since he has not seen original sale deed, so he cannot say that whether volume entry is correctly recorded or not, and entry in volume is not in front of him.
You see any discussion in connection with any mismatch in the sale deed, etc. Right? It cannot go beyond the pleadings. Had it been there in the pleadings that there is an error in the registered sale deed with respect to mentioning the plot number, the situation is different. The other side has an opportunity to rebut or to respond. But automatically the court will not venture into this.
Then,
So therefore, whenever a suit is filed, the court will see the plot number and other details as recorded and as per the registered. Otherwise, what will be the sanctity of a registered sale deed? Useless. Anybody can say that there is an error in the registered sale deed.
there are a number of plots were sold,
You see, we
transferred
do
to
not
that.
know what right created when.
It is as per the record.
As per the record, you were
1.02 acres of land was
you were
sold.
claiming 2198. The records indicated that it was 2198, and in the registered sale deed that 92 was very faint, right? And therefore the
Confusion
actual
arises.
case number was the actual plot number was apparent from Exhibit 5 and 5 by 1, which was brought in from the registry office. You can't have
But
it.
as per physical
No,
policy,
that is not
they-
enough.
and
No.
they have the plaintiff has never challenged that one.
Need not.
My position has not never been challenged.
You are in
earlier.
possession.
Yes,
You remain in possession.
I am still in position.
You remain in possession.
But now the first appellate court,
You remain in possession.
now the first appellate court, therefore I find and hold that the plaintiffs are entitled to right title interest as well as possession of 1/4 of the suit land, that is 2 and 1/4 decimal plot number 2198 area out of 9 decimal. This has been held.
Right
Up to
title
that.
and interest. There is no order of recovery of possession.
Nay, That is
नहीं है ना?
that is not
वहाँ पर
there.
आराम से रहेंगे.
It is not there,
happy.
but automatically then they will chaos will be created.
No, what chaos? Nothing.
Already
You
one
have not taken
even
You
the
see,
suit was
you
itself
have
they
not
barred by
taken-
limitation.
No, whatever it is. Your entire case was rested on a registered sale. And the registered sale deed, the plot number is different from what you claimed.
The original suit has been filed by the plaintiff. I am the defendant.
That's right. Whosoever has filed this particular deed, when there is a mismatch, was exhibited by you.
Yes.
You were claiming on the basis of this particular deed,
Yes.
correct?
Yes.
Now, this particular deed is indicating that the property which you claimed is not matching with your registered sale deed.
But as per it is not. There is typographical mistake or
From
error
where
in
do
the.
you see, even if there is a typographical mistake, you have to plead that there is a typographical
It is
mistake.
not there, but in the
That
as per the recital of the sale deed,
No,
there is specific boundary.
no,
Yes,
no.
yes. it is.
Even if
I
खलियान तो कितना ही होगा
नहीं ऐसा नहीं खलियान टाड़ा और
खलियान का कितना
I'm
होगा?
just
How do you identify the property by खलियान
yes,
का?
no, not only that. There is boundary, specific boundary, east, west, south, north. And I am relying on judgment law. Let's see. May kindly be considered. Para 6 is.
बिना फैक्ट के जजमेंट मत पढ़िए, पहले फैक्ट पढ़िए. Read para 2.
Para 5.
Para 2.
Well, this appeal by special leave is by the legal representatives of the original plaintiffs of West number so and so on the file of Musib Madabad Gobaran at Azamgarh. This suit was one for a mandatory injunction directing the defendants in the suit to demolish further construction put up by them and to fill up a well dug by them in the property claimed to belong to the plaintiff. The plaintiff claimed title and possession over the suit property which was described in the plate and report demarcated in a sketch. The claim of the plaintiff was that the construction had been put up in plot number 1301/1 BA in village Sarhan Pulla, Pargana Mahal, district Azamgarh. The defendant resists the suit essentially on a plea that the construction put up by them did not lie in plot number 1301. They of course denied the title and possession claimed by the plaintiff over the proportions in which the construction and the well stood. The suit had a checkered career. There were repeated remands of the suit. What is seen is that ultimately the question boiled down to that of identification of the property with reference to the disputed portion. Ultimately, in the present round, the trial court decreed the suit, holding that the plaintiff was the owner of the suit land which had been identified on the spot and was hence entitled to the reliefs claim. An appeal filed by the defendants was dismissed, holding that the disputed constructions lay in the suit property described in the plaint, that the plaintiff had title to it, and that the trial court was hence right in decreeing the suit. Thus, the appeal filed by the defendants was dismissed. The defendant filed a second appeal before the High Court of Allahabad. The High Court upheld the findings rendered by the courts below that the plaintiff was exclusive owner of plot number 1301/1 BA. The High Court found that there was no illegality in approach made by the courts below in arriving at the finding, and the finding was based on the evidence on record. But in spite of this finding, the High Court reversed the judgment and decree of the first appellate court and dismissed the suit on a finding that there was no proper identification of the suit property by the plaintiff, either in the plaint or at the spot, and since the boundaries cannot be ascertained without surveying the adjoining plots, no decree could be granted to the plaintiffs
The identification in this particular case
Yes,
was
identification.
duly done by a commissioner,
Yes,
local inspection,
yes,
and the suit property was duly identified.
yes.
Right? It is not a case where the any sale deed etc. is.
No. That is not there. But the para 6 may kindly be seen.
I've seen.
Directly I am coming to the para 6. The High Court has also upheld the title claimed by the plaintiff over the suit plot number 1301/1 BA. Once we accept the identification made by the commissioner as was done by the first appellate court, it is clear that the plaintiff has the right to have the disputed construction removed and the well filled up. That a property can be identified either by boundary or by any other specific description is well established. Here, the attempt had been to identify the suit property with reference to the boundaries
See,
and the commissioner.
just a moment. In a case where you are claiming title by virtue of a registered deed of sale,
There is also
Right.
a boundary is there.
no, boundary must be there. There is a
Boundary is there.
registered deed of sale, and you do not take a plea that the plot number is wrongly mentioned therein. Then how the court can enter into this kind of a dispute? You should have been fair enough to say that the plot number is wrongly mentioned. You did not say so.
It is not. But I am in possession all
You
along.
remain in
Even the description of land, as per the description of land, the land is Khalianta. And whereas the 2192 is Kabrastanta. 2192 is Kabrastanta. It is there. Even in the judgment it has come. उस सब महत्व का प्लॉट है, खतियान से बिलोंग करता है. ट्रायल कोर्ट का पैरा 22 पैरा 22 में स्पेसिफिक कर दिया है. I further find that on the other hand, the defendant's witness DW1 and DW5 stated before court that after purchase of the suit land from Jonglu, BB Mako came into possession of the suit land, and after getting land, she got the land muted in her name and started paying rent to the government. DW6 stated in that she is submitting the attested copy of old RS map of village Sinha and new map relating to the same village. The original Hall survey map is marked Exhibit B. As per the defendant's case, the new survey khata plot number 2453 R 0.08 acres is registered in the name of BB Mako. It is also case of the defendant that from purchase, a purchase area 0.09 acres from RS plot number 2198, 0.01 acres of land was gifted to Idga for the use of common people by BB Mako. Find Exhibit G and G by 1, which is a certified copy of the present survey Khutian of Khata number 657 and 656 shows that the record dated in the name of BB Mako. In this way, it has approved by the defendant that the new survey Khutian of Khata number 657 and 656 is recorded in the name of BB Mako. And they have never challenged this.
Who produced the registered deed?
Both from both sides.
No.
Means I have also produced. The defendant has produced.
Who produced the original deed?
Registered original deed I have produced.
You have produced the original deed, where it was mentioned 2192. And in the registered deed it was found 219. Isn't it?
Original registered sale deed BI number 2693 dated 3856 Exhibit A defendants. तो पैरा 24 का 4 में इसका रिफ्लेक्शन है ट्रायल. Now I find that it is a case of plaintiff that the RS Khata number 89, plot number 2192, but under misconception did executed.
ये misconception word कोर्ट कहाँ से लेके आए? Out of the pleading.
नहीं, ट्रायल कोर्ट का ये
No,
फाइंडिंग्स
where
मैं
is the
बता रहा हूँ।
foundational pleading to this effect?
2198. On the other hand, it is a case of the defendant.
Misconception. Who will say misconception? The court would say or the parties would say? देखिए, हो गया?
I think it is perfect, my. But my lord, only thing is that मेरा चैम्बर जो इस हाईकोर्ट के बिल्डिंग का सबसे अंत में, वहाँ से यहाँ आने में जो देरी है, इसीलिए हमको देरी हुआ.
नहीं,
Otherwise,
कोई
my
बात नहीं,
junior
आपने
was.
देख लिया ना,
हमने
आपका
देख
right
लिया.
protected है.
मेरा right
बस.
protected. I am grateful.
Other side भी देखना चाहे तो उनको खबर कर
हाँ, वो
दीजिए.
देख रहे हैं.
आप देख लीजिए उसको.
इसी में है a certified copy of the same registered sale deed, photocopy of the same volume entry as sale deed which has been executed by say example in favor of the BB Marco. I find that exhibit 5 and 5.1 the plot number is mentioned at 2192. On the other hand, dependent had got exhibited the original sale deed which is exhibit A executed in favor of BB Marco. I find from the result of exhibit A the plot number which has been purchased by BB Marco is mentioned at 2190. Fine, I find that it is the case of the plaintiff that since the plaintiff, since plot number 219 it is not being purchased by BB Marco, so she do not have any right, title, interest over it. I find that the dispute exists between the parties is whether BB Marco has purchased plot number 2192 or 2198. I find exhibit 5 and 5.1 and exhibit A, the name of the land is mentioned as Khalianta. I further find that exhibit 2 is the certified copy of RS Khata number 89. RS Khata number 89, exhibit 2. And same exhibit E, which shows that RS Khata number 89, plot number 2198, the name of the land is Khalianta, while the name of plot number 2192 is Gaurastanta. So, under such circumstances, when there is dispute regarding plot number, whether it is 2192 or 2198 or 2192, I am deciding the dispute according to the name of land, as there is a very minute difference in writing between the Hindi numeric digit 9 and 2. I find that in all the registered sale deed which has been exhibited on behalf of both the sides shows the name of land as Khalianta, all the sale deed. And from perusal of exhibit E, which certified copy of Khata number 89 shows that against plot number 2198, the name of the land is Khalianta. Under such facts and circumstances, I find and hold that the RS Khata number 2198 under RS Khata number 89 is being purchased by BB Marco. Thus, on the basis of discussion made above, issue number 78. Moreover, if the original plaintiff is giving 1/4 share, then obviously she ought to have been filed a suit for partition and not for declaration of right, title, interest. And it is hopeless barred by limitation. फर्स्ट अपीलेट कोर्ट का इसी पॉइंट पर प्लॉट नंबर का फाइंडिंग्स जो है रनिंग इंटरनल पेज 16 से 16 का मिडिल for the perusal of exhibit 6.
was never your case that there was an error in this one.
Yes.
It was never your case. Or the learned counsel appearing on behalf of the applicant. This appeal has been filed against एडिट पोर्शन लिखा ही नहीं है. Against the judgment passed by the District Judge Woman 4, Lohardaga, dated 20/12/2019, in the bracket decree signed on 4/1/2020, passed in title opinion number 30 of 2012, reversing the judgment dated 29/8/2012, in the bracket decree dated 7/9/2012, passed by the Civil Judge Junior Division number 4, Municip, Lohardaga. Entitled suit number 9 of 2003. The suit was dismissed. And the appeal was allowed. Consequently, the defendants are the appellants before this court. The learned counsel for the appellant has submitted that essentially the suit was in connection with plot number 2198 of Khata number 89 area 9 district of Khata number 89 and the defendant claimed that they had purchased the suit property by registered sale deed bearing number they had purchased 1.02 acres of land by registered sale deed bearing number 2693 of 1966. He has submitted that the learned trial court dismissed the suit by observing that the identity of the suit property was by observing that the issue was whether the plot number in the registered deed was 2198 or 2192, and observed that there was a very minute difference in the registered sale deed exhibited by the defendants and proceeded with respect to the identity of the suit property as Kalyan Park. He submits that thereafter the suit was dismissed. However, the learned first appellate court has reversed the judgment passed by the learned trial court by referring to the Exhibit 5 and 5 by 1, which was a document produced from the office of District Sub-Registrar Lohardaga, in which, with respect to the registered sale deed, plot number 2192 was mentioned. The learned counsel for the appellant has submitted that once the identity of the property as Kalyan Park was established, it made no difference if there was an error in the registered sale deed by recording the plot number as 2192 while recording the plot number. He submits that this aspect of the matter was properly considered by the learned trial court, but the learned first appellate court has wrongly reversed the finding, and accordingly a substantial question of law being framed. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in 2006, Supreme SC 584, and has referred to paragraph 6 and has submitted that it has been held that the property can be identified either by boundary or by any other specific description, and either by boundary or by any other specific description is well established. However, during the course of argument and upon a query made by this court, the learned counsel for the appellant has fairly submitted that it was never the case of the defendants that the plot number was wrongly mentioned in the sale deed, or there was any error in connection with the sale deed. After hearing the learned counsel for the appellant, this court finds that the suit was filed by the plaintiff seeking a declaration of right title interest over the suit land mentioned in Schedule A of the plate in connection with village Senha, P.S. Senha, District Lohardaga under RS Khata number 89, plot number 2198, area 0.2.5 decimal. and also seeking a relief permanently restraining the defendant from disturbing the peaceful possession of the plaintiff with respect to the suit matter. The case of the plaintiff was that the suit property कल लिखाएंगे बाकी partly detail.
All right.
I need to raise somebody's waiting. हाँ बोलो.
ऑर्डर्स का किस वक्त कल पे रख सकते हैं या नेक्स्ट वीक
मुझे next week में आ ही जाएगा after से. We don't.
नहीं नेक्स्ट वीक
Next week आ जाएगा. आप भी किसी पे खड़े हैं?